Hello everyone, and continuing with our previous video in which we have discussed about 20 to 25 questions from the industrial relations, let us move forward and see some of the important MCQs from the Trade Union Act. Question number 26, the Trade Union Act 1926 was enacted primarily to. We have seen that the Trade Union Act was provided to provide some rights to the trade unions, and before the enactment of this Act of 1926, the union was basically considered as the criminal conspiracy under the IPC section. To regulate the working condition or to provide for registration and rights of trade unions. So this would be the correct answer. Question number 27. The first trade union in India was established in, and this is one of the important questions from the trade union. And the first trade union was established in 1890. And we have seen some of the trade unions such as the International Trade Union Congress. Then we have the Mazdoor Sangh, Bharatiya Mazdoor Sangh, etc. So question number 28. Which one of the following is a central trade union organization? The Central Trade Union Organization is INTUC, that is Indian National Trade Union Congress. Let us move to question number 29 and see minimum number of members required to apply for registration of a trade union as per the Trade Union Act 1926 is number 7. Option number B is the correct answer. For question number 30, which of the following statement about trade union is false? They aim to secure better condition for the worker. This is true. They represent employees collectively. That is also true. They primarily protect employers' interest. It is not the employer's interest, it is employees' interest. Okay. So this would be the false statement with respect to the trade union. Question number 31. The process by which workers and management negotiate terms of employment is known as. What is the process known as in which the workers and the management negotiate the terms of the employment? That we have seen, that is known as the collective bargaining. Question number 32. Which one of the following is not a stage of collective bargaining? In the collective bargaining, we have seen there are different stages. Which one of the following is not a stage in it? Question number 32, correct answer would be adjudication, preparation, negotiation, agreement, implementation, and then what you can do is after the agreement tenure is complete, you will negotiate or sign as restart the agreement that you can do. So adjudication is not done in the collective bargaining. Adjudication is basically done in a tripartite uh, conflict resolution methodology. Question number 33. Productive bargaining implies to productive bargaining will basically link wages rise to the output increase. We have seen different types of conflict in which we have seen also the different types of conflict resolution technique out of which this question has been asked. The question is productive bargaining. So it link wages with productivity. Question number 34. Which type of dispute concerns the interpretations or implementation of existing agreements? Existing agreements, right dispute means something right, something is the right of the worker and that has been already assigned or already decided, but that is not being implemented or not being given. So it is the right dispute. Question number 35. Under the Industrial Dispute Act of 1947, strike is defined in section. See, we have not discussed the Industrial Dispute Act. In the previous video also there was one question from the Industrial Dispute Act. Here also we are having one question from the Industrial Dispute Act, which gives you a hint that the next video will be discussing detail about the Industrial Dispute Act. So under which section strike is defined? That is defined under section 2Q. Which one of the following is not a recognized form of strike? We will, for the time being, we will skip this question as we have not done this industrial dispute wherein we will be seeing the different type of strikes and what are the legal and recognized form of the strike and what are illegal form of the strike that we will see. Then we'll come back to this and then answer this question. Which one of the following is a bi-party body under the Industrial Dispute Act? Bi-party body is Works Committee. Conciliation officers are appointed by. Who appoint the conciliation officer? It is appointed by the central government or state government, depending upon the basically under which the respective trade union are basically registered under which government? Either it is registered under the state or the central government. Accordingly, the conciliation officer will be appointed. The function of the court of inquiry is to, it will basically inquire the details. So, court of inquiry basically investigate the facts, and the judgment is not binding. That means it what it will recommend is not binding on the either of the party. So the correct answer would be the punish worker, no. Conduct fact finding about dispute, yes. The labor code deals with which schedule of the matter? The labor code basically deals with the second schedule, that is standing orders or dismissal. Second schedule, and it deals with what? Standing orders, standing orders or dismissal. Moving forward to question number 42. Which body adjudicate disputes of national importance? National Industrial Tribunal. Voluntary arbitration under the Industrial Dispute Act is provided in. The voluntary arbitration is provided under section 10A. Under the Industrial Relation Code 2020, notice period for a strike or a lockout is, see, it is basically there is a mandate for 14 days of notice for all establishments. So correct answer would be option B, that is 14 days. Question number 45. The Industrial Relation Codes 2020 raised the threshold for permission of layoff retrenchment to 300 workers. Earlier it was 100 worker. Now it has been raised to 300 workers. So if you are having a 300 employees in your organization, before laying off or retrenchment, you will have to seek permission. So next question 46. Which new concept was introduced in the IR code for retrenched workers? There will be a reskilling fund. For retrenched worker, there would be a reskilling fund. And with this reskilling fund, the retrenched worker will be reskilled. You have lay off the workers, you have retrenched the worker. That means they were not able to meet the requirement of the industry because they were not skilled. So you have to skill them, and then you will again have to employ them back if they are skilled. And for that, you uh, have to like have a reskilling fund. The Indian Labour Conference was established in. That question is like too much theoretical, and that would not like expected. But even though I have included that, so it was established in 1942 because Indian Labour Conference is Indian Labour Conference is an important topic. So we will be discussing that also. But it was established in 1942. Which approach of industrial relation assume unity of interest between employer and employee? That is the unitarist approach. Then the system theory, we have seen this previously also. The system theory of industrial relation defines which three element. The system theory was given by whom? It was given by Dunlop's. So what is said, it defines the three elements, and that three elements are basically what? Actors, then there is a context, and then there is a role. So option A is the correct answer. The second National Commission on Labor 2002 recommended what? It recommended merger of labor laws into four codes, and that has already been achieved. So the PDF of this will be uploaded on the Telegram channel APDCIO PREP2025. Search for it, and you will be getting a Telegram channel. The PDF of this will be uploaded. Also, the video and the upcoming video on this APFC series will be uploaded on the YouTube channel, and it will be saved in the playlist known as the APFC. So kindly save that playlist. So this is all with today's video. Thank you so much for watching.